Welcome to another episode of the K-Series podcast. Today we actually have Shona Tarulli, who is our in-house senior general counsel. Shona has been with us for 5 years now and a really big part of our business, manages all of our compliance, risk, contracts and legal training with the team. So welcome, Shona.
Thank you, Michael. Nice to be here.
Yeah. I think it's probably a bit opportune to have you here just to talk about some of the changes that are now happening coming into the 1st of August. So in a couple of weeks' time, we've got new seller disclosure coming in and interested to hear how that may impact the both buyers and sellers in the market and potentially agents as well.
Sure. So, yeah, it's 1st of August coming up very soon. We've been 8 years in consultation, so it's a really long time coming, but it's finally here. It will significantly change the property law landscape in Queensland, and we're kind of learning on the go in terms of we don't know long-term what it's going to look like in terms of how it will develop, and agents, solicitors, I guess the entire market will come to adapt to the changes in terms of whether contracts and all those kind of things will be prepared by agents, solicitors, or what it's going to look like. So we are very much learning, as I say, as we go. But from a seller's perspective, it is significantly more onerous now to sell in Queensland. The purpose of the legislation was to balance cost in terms of buyer and seller and trying to, I guess, reach a middle ground in terms of disclosure and probably bring Queensland into line with New South Wales and Victoria, where they do have that upfront seller disclosure. The legislation largely mirrors what the REIQ contract previously already had in terms of warranties, but it's now an upfront disclosure as opposed to a buyer trying to do those searches mid-contract and I guess find the information while they're under contract, and then it's a breach of a warranty as opposed to something at the outset. But it doesn't change, as I say, it doesn't really change the seller warranty position in terms of the seller was already warranting most of the matters anyway, but it is significantly more onerous from a perspective of, for instance, if you fail to attach a title search, there's a termination right for a buyer all the way up until settlement. So there's things that
Is that even when there's no materiality, so someone hasn't attached a title search, but there's no issue with the title and then they still have a termination right?
Yeah, so there's 4 grounds generally on which you can terminate. The first is a failure to give the disclosure statement. You've got a failure to attach a prescribed document. One of the prescribed documents is the title search. You've got a plan. There's a bunch of documents there that are defined as prescribed documents. Those two, if you fail to give the disclosure statement or you fail to attach a prescribed document, it's a termination right all the way up until settlement, and it doesn't have a materiality threshold attached. So there can be no prejudice to the buyer. They don't have to have suffered a loss or potentially suffer a loss, and a buyer can withdraw from the contract all the way up until settlement. So really...
So when a lawyer is looking for a way to get a buyer out of a contract for whatever reason, when they've got buyer's remorse, they're obviously going to be trying to find any of these little loopholes which, if they don't materially prejudice a buyer, seems a little bit ridiculous that they're overreaching to that sort of level.
So you're right. I think the first thing that they're going to do is go to the disclosure statement and try and pick a hole in the disclosure statement. I think I would anticipate in the first 12 months, we're going to see a lot of, I guess, solicitors relying on these disclosure statements to get buyers out of contracts. They're going to go looking. If there's a buyer that wants to get out, the most obvious way will generally be you would go straight to the disclosure statement and you would check that disclosure statement. There are 2 other grounds that you can terminate, with the disclosure regime. So the other, there's the substantially incomplete. So the disclosure statement is not fully complete. And the final ground is that it is inaccurate. Those 2 are threshold tested. There is a material. So it needs to be that the buyer was not aware of the facts at the time they entered into the contract. They need to, if they had known of the true facts, they wouldn't have entered into the contract, and they need to be materially prejudiced. You're almost better giving a disclosure statement which has almost inaccurate information as opposed to the first 2 where you don't give the disclosure statement or you fail to attach a prescribed document. You're almost better giving what you can because it then kicks in a materiality test as opposed to the first two where it's just if you miss that document, if someone's pulling it together in haste or it accidentally falls off in a PDF merge or something like that, you're merging certificates and the title search falls out or a document falls out, it's really risky territory for a seller. It's great for a buyer. But because the seller doesn't have the same termination rights, they can't terminate to cure the breach and then re-enter. They can't say, oh, we know this is problematic, we're going to quickly terminate and re-enter. So they're just having a buyer sit on a termination right all the way up until settlement. So
it becomes a bit frustrating when people actually purchase something else and think they've sold their own home and opens up a minefield for potential litigation and against multiple parties.
Yeah, and look, I think we're all live to that. It's a really scary time in Queensland to be a property lawyer. In terms of if you're preparing the disclosure statements and you get it wrong, then you're giving the other side a termination right. If you miss a termination right and your buyer wanted to get out or it was material to your buyer, you've got a really big problem. I think from an agent perspective as well, if the agents are preparing the disclosure statements, you wouldn't want to be an agent on risk. I guess the benefit is that, Kollosche has lawyers, so but I wouldn't want to be a broader agent in the market that's just pulling together disclosure statements on their own because they're certainly on risk and it's really dangerous and murky territory. We've also seen that the Form 6 appointment, the REIQ has amended that so that there's a new entitlement to commission, and that entitlement to commission arises in favour of an agent where although a buyer terminates the contract because the disclosure statement was inaccurate or missing a document, the agent is still entitled to commission.
Yep.
That's going to, I think, be a minefield as well because you've got a seller who's lost their buyer. They've had to refund the deposit to their buyer, but they're still liable for commission to their agent. So there's a lot of scope for it to go wrong.
Yeah. And you say they had an 8-year consultation period, but I don't see much of that coming across my desk for consultation when we've got a lot of industry experts with senior agencies in southeast Queensland and Queensland alike that probably should be consulted on some of these things because we're doing them on a daily basis and can put some practical sense around it. So without sort of, I know you're probably restricted on what you can say in regards to comments, but I'm happy to sort of give my opinion on it. And I would expect that some of these termination rights should last 7 to 14 days, almost like a cooling off period, rather than having this ongoing entitlement that can potentially cause significant issues for purchasers. And we saw it with their introduction of a 5-day extension on settlements. And when that came into effect, I had this lovely old lady who was 80 years of age who settled her house one morning and was expecting to settle her purchase that afternoon. And the seller of that hadn't moved out and invoked their 5-day extension. And she had her removalist turn up with all the furniture. And next thing we had to put her up at the casino for the weekend. And they were like, well, we don't care. You can leave it on the grass. And the removalist had a job the next day. And so some of these things need some practicality put into them. And I'm happy to debate them with anyone at any level of government or REIQ or OFT because we really need to find a way that some of these things can work well where buyers and sellers are protected, but it's not creating additional minefield for them to navigate so that lawyers can enjoy more litigation and make a lot more fees at the behest of everyone else on technicalities. But I don't want to get too far off it. So let's talk more around.
Cut you off there because there is a couple of things I will say to that. I think we will see, and I could be wrong on this point, but fairly quickly a bit of reform almost to tidy up some of those practical issues. So, for instance, in New South Wales, this regime, a seller disclosure regime, has been in place for many years. It works relatively well. There's a 14-day termination right for a failure to attach a prescribed document.
Yep.
Effectively, this contract lands on the solicitor's desk. You can identify it. After the 14 days, they no longer have that right. I think that's reasonable.
So wouldn't we model the...
And look, it hasn't been, and which is why I wonder if in practice we will start to see, I guess, some issues like the things that you've just raised and potentially they'll be addressed.
8 years wasn't enough time for people to figure that out? Don't worry, I know you don't have to comment on that. So. But we're rolling things out that are going to cause some significant issues, and ultimately we will adapt, and we're fortunate because we have 2 in-house lawyers and a lot of training and support, and we are very diligent in the way we prepare everything anyway, and we go above and beyond with all of the material that we disclose and prepare when we bring properties to market. But you can obviously see that there will be some challenges there, and these things, I think we've just got to get better at rolling them out personally.
Yeah, and look, I don't disagree. I think there's certainly, I think, will be some very quick learnings from the regime, and solicitors, agents, everyone is going to have to adapt. I think it becomes really important to have the right team, because you want to know that you've got the right agent who understands, the disclosure. They understand what they're doing. They're not just fumbling their way through it, because I think we probably will see that in the market as well, in terms of it is such a big legislative shift. It changes the entire landscape. And so you're going to want to make sure you've got the right agent. You're going to want to make sure that you're appointing a property lawyer that practices all day in that area and knows what they're doing. There's so much scope for error that I think we're going to have to very quickly shift to a position where there is no scope for error left, in terms of we need to make sure that people are getting it right from the outset. And I think that's going to be the really challenging part. And I think the REIQ, I think QLS, everyone's going to struggle with that, in terms of I think it will for some time cause issues. And
I guess on the flip side of that, we've now got a lot of search companies that are coming into the market, and they're looking at how they can secure the business to prepare these things on behalf of clients and agents, but sticking agreements in front of us that they want us to be able to let them own all of our data so that they can do with it what they want and sell it to whoever they want to. And some of those search companies are actually partly owned by major real estate firms that they won't actually disclose who the beneficial owners are.
And we've seen that already. Yep. We've seen there's, I guess, some really fast-moving businesses and businesses that have popped up that are in this seller disclosure space now, and you've seen real estate agents take advantage of that and market this product to the market, and they're preparing the disclosure statements. But it's affiliated with either an agency, or they've got these terms in their agreements which says that we own the client information. We're entitled to do with that what we wish, so we can sell it to a real estate agent down wherever. We can sell it to all the Gold Coast data to a Gold Coast agency or Brisbane or wherever it is. So you've certainly got people that I think are finding opportunities in the legislation and trying to exploit that as well.
So let's probably delve a little bit more into what the searches actually are, what they're supposed to do, and how they protect the consumers. Obviously, we're all going to have to move forward with this, so we've just got to adapt as we always do, and we're probably in a little bit more of a fortunate position because of the in-house legal counsels that we have, and the support that we have as a business, and the fact that we've been preparing well in advance. But if you want to just talk through some of those, and I guess what if there are any sort of positives to various buyers and sellers on how it can support them, and cover off on that.
Yeah, look, I think there's certainly, I guess, the benefit to the buyer in terms of, I said, that cost benefit. Not all conveyancing practices are doing. So some of the searches that need to be attached, you've got a title search, you've got a plan, which any prudent solicitor should be doing anyway. Your agent should probably be doing those searches as well at the outset, understanding what's on the title and making sure that they don't inadvertently give a termination right under the contract. There's a lot of the searches, though, as I said, are covered by the warranties in the REIQ contract anyway. So you've got a transport search, you've got a contaminated land search, a heritage register. And you don't actually have to attach the searches. You just have to disclose if they're on those registers. So transport, contaminated land, you've got an EPA search, that's the contaminated land search, the heritage register. If there's a whole bunch of others, but if it's in a CMS, you need to attach the CMS, all those kind of things which are discoverable by public record. Great for a buyer. The likelihood of land on the Gold Coast on Mermaid Beach being contaminated, probably not relevant. A heritage search, probably not relevant. What's not there is things that a buyer would probably want to know, like, has the property been subject to flooding? Has it had significant flood ingress? And a buyer is going to want to know that. Is there unlawful development at the property? There is the requirement to attach a notice or an order. So if the buyer's got a notice or an order from council, you do have to attach that. But there's a huge amount of development on the Gold Coast that isn't approved and you don't have to disclose that to the buyer. So that's not something that you would draw out in this disclosure statement, which I think you would. It's almost a shame that it's not drawn out, because that's the stuff that I think a buyer really wants to know about, and it's going to significantly affect a buyer if there's a whole piece of unlawful development on their land and council comes along once they're the owner and issues a notice or an enforcement order.
Or resumption.
That's exactly. Well, resumption is included, but it's more those, I guess, the things about the property where it somewhat falls short in terms of not disclosing that, which as a buyer solicitor, you're on risk for. If you don't tell your client that looks like it's unlawful or make those investigations, and the seller doesn't have to disclose that. So
tell me about auctions. How does it play out there? If something's sold on the fall of the hammer, do they still have termination rights as a buyer?
Yep. So generally, in terms of the auction, you would sit the disclosure statement there, and it's taken that if it's sitting there at the auction, that's okay. They've received the disclosure. But certainly it used to be the position, and I mean, you would still have the contractual warranties and things that are all there unless you're buying something on an as-is, where-is basis, which would be covered by a special condition. But certainly the auction doesn't take away the failure to give a disclosure statement, material inaccuracies, those kind of things. It's still all a termination right for the buyer all the way up until settlement. So you don't have...
So someone can go and spend $10,000, $20,000, $30,000, $40,000 on marketing, sell their property at public auction for a fantastic price, and then a document may have been misplaced or not added to the contract, or maybe an error, and it gives a termination right there too.
Less so the error, because that gives rise to the material inaccuracy, which is... and the fact that the buyer would have to be prejudiced, which is why I say you're almost better giving a disclosure statement that has an inaccuracy as opposed to not giving. And look, I would never advocate for that, by the way, but as opposed to not giving it or failing to attach a document. But yes, certainly there's going to be, I think, a significant amount of sellers we're going to see out of pocket and in a really difficult financial position, because the buyer is entitled to terminate and the entire deposit is given back to the buyer. There's no compensation. There's no loss of opportunity or anything like that. They get everything back, and the seller is left effectively with no contract. The marketing is spent. They've gone through the auction process. I think it's also, from a perception perspective, going to be difficult as well, in terms of if you see this beautiful auction that was run in an incredible way, and then, it's all over social media and things like that, and all of a sudden the seller's going to have to resell it again, and it's going to beg the question, what happened? So I think, there's huge scope there's also just scope for embarrassment in terms of agents, solicitors. It's a scary time to be a property lawyer.
And so you'd think that these things would have to be challenged or discussed, or people putting these things together would obviously have to take some of these things into consideration, because when you look at it from a practical sense, clearly if someone had sat down and actually done a proper consultation with a lot of leading agents across Queensland, these questions definitely would have come up. So I find it challenging and perplexing that they roll these things out without actually giving any thought to the impact that it will have on the consumer, because it's one thing to protect a buyer and wrap them in cotton wool and give them every bit of termination right they possibly can, but the client is also the seller, and the seller here is someone that can end up losing their house, millions of dollars, hundreds of thousands of dollars, whatever it might be, because they go and commit to another purchase after they think they've sold their house unconditionally, and then they end up getting tripped up on a termination right and lose their own deposits on the next purchase. And so the complexity here is not great for...
Yeah, and look, it's not to say they didn't or that they didn't consider it, but I think, as I say, it will play out very quickly, I think, in terms of, and I could be wrong, we may have this legislation for many years to come and it may remain unchanged, but maybe
they'll watch this podcast and might give them a few ideas, and in the future they might actually come sit down for consultation with any of the industry leaders in Southeast Queensland. So I'm sure they could get plenty of them together in a room and would have plenty of opinions to discuss.
Yeah, and look, I think they're open to that. So I think, and I think the best thing we can do is advocate and give them that feedback particularly as it plays out. But at this point, we have the legislation, and we're going to need to adapt and learn very quickly. And as I say, I think we are well placed to do that. But I think there's definitely going to be.
Is there any way of contracting out of these things with special conditions or?
No, with the special conditions, there are some exemptions as to when it won't apply. One of the big ones is the 10 million plus properties. However, the buyer actually has to opt out. I would say as a buyer, why would you? And I mean, it's intended to target that sophisticated buyer that is very capable of understanding and obtaining its own legal advice. But
you'd say that a threshold of 10 million is probably a bit exorbitant and it should probably be sitting closer to 5 or less.
Yeah, but I think we're also going to see that is also problematic in terms of what if you've got a property, say, at an auction and you think it's 8, it's suddenly 10, or you think it's going to sell for 10, it's suddenly 8, and you didn't give a disclosure statement because you thought it was going to sell for 10 mil, and the buyer opted out, but it sells for, that's exactly right. Like to me, and I could be wrong on that, but to me that's almost what if the buyer opts out and then the price is less in an auction or something like that? So I think in practice, we're just going to give it. We're not going to run that risk.
Yeah, look, I think it's going to have to come down to a point where all that due diligence is going to be done and provided prior to auction, and you turn up and register a bid at auction, you buyer beware, as it's always been, because if it ain't broke, don't fix it. And so my view is that if you're purchasing a property at auction, maybe they need to reconsider that, because you're exposing a lot of people. Doesn't need a threshold. And if you want to put a termination right, give them 7 to 14 days post-contract for their lawyers to do their searches and everything else that they need. And that allows us to move forward with confidence, and for other people to make offers on properties subject to them settling or subject to the 14-day threshold passing or something like that.
Absolutely. So, and I really advocate, I think seller disclosure is generally a good thing, but I think it should stop at a point, i.e. 7 or 14 days like New South Wales, because as you say, you don't want to be in the seller position of contracting to buy something else and they pull the pin at the last minute. I would be lying if I said I wasn't worried that people would use this as a negotiation tactic for a price chip. So if they know they're sitting on a termination right, there is no entitlement to compensation, by the way. So for the things with the terminations, it's a terminate, or unless it's under another statute where you're entitled to compensation, in which case you would terminate under that legislation as opposed to under the seller disclosure regime. But I think we will see not compensation per se, because there's no entitlement to it, but you'll see potentially buyers, solicitors writing to the seller saying, you know, the buyer has a termination right. We're at liberty to exercise that all the way up until settlement. And unless you agree to reduce the purchase price by X, Y, Z, we'll exercise that right. And if you're a day before settlement, you've backed them into a corner.
And they've purchased something else.
That's right. And I hope I'm wrong on that point. Yeah. But I guess
I doubt that you are.
I think I'm right. I think that we will see that being deployed. Exploited. Yeah, where people do still want the property, but they have a right. And, you know, I think, I'm not convinced that won't become something that we see.
No.
So
I guess, look, this is probably where choosing the right agent that is extremely diligent, that prepares everything properly, that is aware of all the disclosures that need to be made, whether they agree with them or not, is going to be more crucial, because if you're dealing with cowboys that are very loose in their paperwork and their process and what they do, and then you are going to find that these things may not come up all the time, but they will come up when people or lawyers decide they want to find ways to either exploit it or get termination rights. Nice to have you on here just to share this for the broader community, for everyone. I think discussing these things openly is important because it allows people to frame or reframe some of these things so that there's less risk and consumers aren't actually hurt and burnt. I'm just as concerned about the buyers as I am about the sellers, and I think exposing them to some of these risks just through things that may go wrong, or errors, or an admin mistake or something like that. We saw it back 20 years ago with Form 30Cs, when they had to go on the front of a contract and people would debate and argue that it was signed not on the front of the contract, and it had become their word against yours and hearsay. And so it's and people actually got out based off that, even though they were structured properly. It just came down to an argument, and so we saw plenty of that. So hopefully there will be some reform around these very quickly. Maybe we'll get this issue out quite quickly and they can make the reform before it comes out. That'd be nice. But in any event, appreciate you coming on to share some of these thoughts and also just cover off on the legislation.
Thank you.
Thanks.
Pleasure.